friends. In this video, let us discuss some of the editorials in the Hindu paper dated 9th April and 10th April. Now, the topics that we will discuss in this particular video are the draft forest policy. This is the new draft forest policy that has been drafted by the government of India. So let us look at some of the problems with this new draft policy. Then comes the Dalit agitation. So there we have seen that last week the Dalits have come onto the roads and they have agitated, and let us see some of the reasons why the Dalits are agitating. And next, the third one is related to triple talaq. The government has come up with the triple talaq bill. So therefore, there are some problems with the triple talaq bill. Let us look at the counter arguments that have been given against this triple talaq bill. And the fourth one is related to the Patents Act of 1970. Now, this we will be not discussing the entire Patents Act of 1970, but we shall look at specifically the Form 27. Okay, this is a form that has to be filled by a patentee who has taken a patent. So therefore, we shall look into this Form 27 and its significance when it comes to the health, the general health scenario in our country. Okay, so these are the four topics that we shall discuss. Now, let us look at the first topic. The first topic is related to the forest policy. So this is a new draft forest policy has been laid out by the government of India. Now, this is not the first time that the government is coming up with a forest policy. The government India has a forest policy. The first forest policy in India came up in 1894 itself. So therefore, then that forest policy got revised in 1952 and also in 1988. Okay, if you look at the 1988 forest policy, then you find that the policy has given importance to protection of forests, conservation of forests, and also development of forests. Now, what is the gist of the article? What is the article talking about? As I have already told you, the article is talking about the new draft policy. If you look at the importance of forests, you find that forests do play a very important role. And if you look at, let us look at a few important points related to forests. The first one is forests provide livelihood. In India, forests provide livelihood to 250 million people. And the second most important aspect when it comes to forests is we have to remember that forests help in carbon sequestration. Now, what is carbon sequestration? Now, this forest act as a sink to carbon dioxide. So therefore, these trees, they generally take in carbon dioxide and use it in photosynthesis. So therefore, the forest would act as a very large sink when it comes to carbon dioxide. So therefore, these are the two uses of forests. Okay, now when you are drafting any policy, you have to take in the previous experiences also. There might be some problems when it comes to the previous policies. So therefore, we have to rectify them in the new policy. So this is what generally we have to do. If you look at the pre-independence era, that is the British colonial era, you find that the government was the sole authority when it came to forests. But post-independence, the situation did not change. The situation did not change until 1988 forest policy. The 1988 forest policy, it recognized the importance of locals, and the people's participation was also encouraged. Okay, so therefore the 1988 policy has recognized the concept of people's participation. However, the community forest rights did not come up until Forest Act of 2006. The Forest Act of 2006 came up with the concept of community rights, and the local people were given community rights to access and manage forests. Okay, and there are few examples, there are many examples, and some of the examples, if you look at states like Maharashtra and Odisha, the tribals in those states have used these community rights to protect their forests. So therefore, the Forest Act of 2006 is very important because it introduces the concept of community rights, community forest rights. However, there are also other examples. If you look at the Adivasis of Niyamgiri in the state of Odisha, they have prevented the bauxite mining in their hills, okay, using this community forest rights. So therefore, these forest rights have been playing a very important role. However, what is the problem with the new draft policy? Now, the author has identified two problems. The first one is the production forestry, okay, and the second one is the public-private partnership when it comes to utilizing the forest resources. So therefore the private players are being allowed to utilize the forest resources. These two things are the major problems that have been identified by the new draft policy, in the new draft policy. Okay, if you look at some of the examples, like the production forestry has led to replacing oak with pine monoculture in Himalayas. Okay, and in Central Asia, the sal replaced by teak in Central India. So therefore these monocultures are coming up. So this production forestry is leading to commercialization of forest resources, which is a major problem. Okay, so therefore these two problems have been identified, and these are some of the examples where the production forestry is detrimental to our forest resources, to our natural resources. Okay, now what has been the impetus behind this new draft policy? There are two things. One single thing has been identified. The thing is granting private sector access to public resources. This is the major problem that the author is identifying. So therefore the forest resources should not be opened up to the private players, because the local people have the community rights over the forestry according to the 2006 Forest Rights Act. However, this new draft policy is talking about the privatization of forest resources, which I don't think is a very good step for conservation of forest resources. So this is about the first article. Okay, thank you. So the second article is related to Dalit movement. Now recently we have seen the Dalits have been agitating. They are coming onto the streets and agitating. Let us look at the reasons why they are agitating. Before that, let us look at the background. Now Dalits have been facing discrimination in its worst form, which we call it as untouchability, for thousands of years. When you look at the pre-independence era, you find that many individuals have fought against this untouchability. People like Gandhi, Ambedkar, Phule, they have all fought against this untouchability. But post-independence, post 1947, the curse of untouchability was to be eliminated using constitutional methods. So therefore constitutional methods were now being used to eliminate this untouchability. Article 17 specifically talks about the abolition of untouchability. Okay, 1955 Untouchability Offences Act came up in 1955. This is not 95, this is 55. Okay, and this Untouchability Act of 1955 was later called as Protection of Civil Rights Act in 1976. In 1976 it was called as Protection of Civil Rights Act. Then came the SC/ST Prevention of Atrocities Act 1989. Okay, now the reason for the Dalits agitating today is that the Dalit communities took to the streets against this SC judgment, Supreme Court judgment on March 20th, 2018, which diluted the SC/ST Prevention of Atrocities Act. So therefore there was a case in the Supreme Court where the Supreme Court said that gave a judgment which actually diluted the SC/ST Prevention of Atrocities Act. Now we are not going to discuss, we are not going to the detail of that particular act. That will be subject of another that would be a subject that we will see later on. But at this point of time, the Dalit community feels let down by the Supreme Court. It feels let down by the Supreme Court because the Dalit community feels that the Supreme Court has diluted the SC/ST Prevention of Atrocities Act, and the Dalit community feels let down because recently there have been many attacks on Dalits. If you look at the Rohit Vemula, death of Rohit Vemula in Hyderabad Central University, if you look at the public attacks on Dalits in Una, or the attacks on Dalits during the celebrations of this Bhima Koregaon battle. So these are all some of the examples where the Dalit community have been subjected to violence. Okay, now Dalits, the situation of Dalits has improved post the independence. Now Dalits today are writing their own histories. Dalits today are writing their own biographies. Okay, they are writing their own literature. They have their own Dalit literature. Okay, they are writing biographies of Ambedkar, of Phule, and many other such great people. However, even though the Dalits are rising in the economic order, the Dalits are today, some of the Dalits they are on par when it comes to the economic status with the other communities. Even though they are on par with the other communities when it comes to the economic status, still they face discrimination. Okay, this discrimination is not this discrimination is inherently in the Indian society. So therefore the social attitude has to change. Without the changing of the social attitude, this discrimination when it comes to Dalits would not go. The other communities apart from the Dalit community must realize that the Dalits are also equal citizens of this country. Dalits are also contributing to the development of this country. So therefore every other community has to look at Dalits as equals. Okay, our constitution talks about integrity and fraternity. The term fraternity was included by Ambedkar. Fraternity in a sense means brotherhood. So therefore all the other communities must take in the Dalit community. They must feel that we are all brothers. Once that fraternity comes into the social structure, then only this discrimination would go. So therefore this article specifically talks about this Dalit movement and the reasons for their agitation. Okay, next let us talk about this triple talaq. Okay, now this triple talaq has been in news for the past 1 to 2 years. Now the focus of this article is on the triple talaq bill. Okay, now if you look at the background, the Supreme Court has banned talaq-e-biddat. Now this is the simplest form of divorce, where a man pronounces talaq, talaq and talaq 3 times and the divorce is complete. Okay, now the Supreme Court has banned such a talaq and it said that such a talaq is not valid, and the government of India has come up with a draft bill which would actually criminalize the triple talaq. So therefore until now there is no provision in the law which actually criminalizes this pronounce of triple talaq. But however, government wants to penalize the individuals who use triple talaq as an instrument of divorce. Okay, so what is the gist of the article? Now the author of this particular article is against this triple talaq bill. He is not against the triple talaq bill. There is a specific point in the triple talaq bill which says that if a man pronounces triple talaq, then he can be jailed for a period of 3 years. The author has some reservations when it comes to this. He says that how can you jail a person for just uttering the words talaq, talaq and talaq? He says that such an act would be against Article 21 and Article 19, and he also quotes some of the previous judgments, Supreme Court judgments also, to validate his point. Okay, so let us look in detail what the problem is. Now he says that there is an act by the name of Prevention of Women from Domestic Violence Act. So therefore we call it as the PWDVA Act. This came up in 2005. Now according to this act, any verbal or emotional abuse is considered to be domestic violence. So violence doesn't mean physically hitting somebody. Even verbal abuse or emotional abuse is also considered as a violence. So therefore there are various definitions when it comes to verbal and emotional abuse. The author says that just uttering the word triple talaq does not come into this verbal and emotional abuse. So he says that the utterance of triple talaq does not come under verbal and emotional abuse. There are also other sections of this act that have been given in this particular article. Section 18 talks about the protection order. Okay, this order is given by the court when it feels that the woman has some danger due to his husband. So therefore then protection order is given by the court. Section 31, if a person indulges in violence, then he can be either jailed for a year or fined 20,000 rupees. So there are already provisions in the act where the person can be jailed for 1 year, but this triple talaq bill talks about jailing the person for 3 years. Which is according to the author too much. Okay, now he specifically says that innocent men would be targeted using this triple talaq bill. Okay, so once this bill becomes an act, this triple talaq act could be used by women against innocent men. Okay, and so therefore this would violate the Article 21, which talks about the right to life. And he also says that He also says that it would also violate Article 19, and Article 19 talks about 6 types of freedom. So therefore he also saying that this Triple Talaq Act, if it comes into force, would also violate Article 19. Now there are 2 Supreme Court judgments that he has come up with. The first one is the Maneka Gandhi case in 1978. What is this case talking about? The Supreme Court has said that the procedure, Supreme Court has come up with a concept called as procedure established by law. It has also come up with another concept called as just laws. So whatever laws that the government comes up with must be just. Okay, they must be just. And according to the author, this Triple Talaq bill is not a just law. If it becomes a law, this would not be a just law. Okay, next. He also quotes another case, the Sunil Batra versus Delhi administration. This is a 1978 case where Krishna Iyer, Justice V. Krishna Iyer, has emphasized the importance of Article 21. So therefore, according to the author, Article 21 is more important than this Triple Talaq Act. So therefore, these are the 2 cases that he has talked about. Okay, so this is about this Triple Talaq bill. The author is specifically talking about this clause or this provision in the Triple Talaq bill where a man who utters this Triple Talaq can be jailed for 3 years, and he says that this utterance cannot be taken as an emotional or verbal abuse, and you can't jail him for 3 years. This would violate his fundamental rights, and 2 fundamental rights specifically talking about are Article 21 and Article 19. So this is the third article that we have discussed. So the next article is about patents and protecting public health. Okay, the focus of this article is on Form 27 of the Patents Act 1970. Okay, let us look at the background. Shamnad Bashir, who is a professor, has filed a public interest litigation before the Delhi High Court. Okay, now he has, this petition is very important. It has pointed out the importance of this working requirements in the Patents Act of 1970. We will see later on what is the working requirement. Okay, so this is the first thing, the working requirements in the Patents Act 1970. The second point is about the need to amend Form 27. And the third one is talking about the lapses by the patentees in furnishing information. So these are the 3 points that this particular article is talking about. The first one is the importance of working requirements, second one is amendment to Form 27, and third one is lapses by the patentees in furnishing information. Now, this Form 27 is very important when it comes to the question of access to health. This Form 27 is very important when it comes to the question of access to health. Okay, let us look at what this Form 27 is. Now, if you let us take a simple example to understand what actually this Form 27 is and what is its importance. Let us say that I am a patentee, that is, I have taken a patent for a particular object. Say that I have taken a patent for this particular bottle. So therefore, once I take a patent for this particular bottle in the Indian Patent Office, so therefore nobody can produce such a bottle for a fixed time period. So therefore, I have a monopoly over this bottle, this structure of this particular bottle. Okay, so therefore I get a patent. Now I am a patentee. Now this is my invention. I have invented a bottle. So therefore nobody else can produce such a bottle apart from me for a fixed time period. Okay, everything is good, but say I have not used my invention to produce bottles on a commercial scale. So therefore I did not produce these bottles on a commercial scale, and I did not sell it to the normal public. So therefore I did not do it for 3 years. So for 3 years I have put my invention in the dustbin. I have been not using my invention, but I have the patent for that particular invention, but I have been not using it for a period of 3 years. So after 3 years, an individual like you can come up to me and say that since you are not using the patent, since you are not using your invention, give me the license to produce that bottle. Since I have not been doing it for 3 years, so therefore a guy like you who is interested would come up to me and ask me the permission or the license to produce such a bottle. Now say if I refuse, what will happen? If I refuse, then what will happen is, according to the Indian Patents Act of 1970, the government has the right to issue license to you. So therefore the government would bypass me and it would give license to you so that you can produce that particular bottle. Okay, so this is what happens in general. Okay, now what is Form 27? Now Form 27 is a form that has to be filled by a patentee, that is me, every year. So annually I have to fill this form. Now what is in this form? This form contains information about the working requirements, whether I have been using this invention or not. Okay, so every year I have to publish it. Now the thing is, today most of the patentees, they are not publishing these reports. And another important point is, apart from publishing whether you have this working requirement or not, I also have to give away information about my invention also. So therefore some information about the invention also lies in that particular Form 27. So therefore once I do not issue that Form 27, so therefore the government would not know whether I have been using that invention or not. So therefore today, if you do not use that Form 27, there is no provision where your patent could be taken back. There is only a fine. So therefore the petitioner is saying that amendment has to happen to Form 27. If you do not fill the Form 27 annually, then your license has to be cancelled, then your patent has to be cancelled. So this is about Form 27. I hope you have understood the problem. So therefore I, as a patentee, if I do not use the invention for 3 years, then the government has the right to give license to the third party. Okay, the third party, and this Form 27 provides information to the government whether I am using it or not, whether the working requirement is happening or not. Now let us take a specific example of pharmaceuticals. If you look at pharmaceuticals, you find that the pharmaceuticals, they produce these medicines, and if I produce a medicine which is related to cancer or AIDS or any other disease, and if I do not produce, now I get a patent for such a medicine, and if I do not use that patent to produce the medicines in adequate number, so therefore what will happen? I have a patent, no other person can produce it, no other company can produce it. I have the patent, I have the monopoly over that particular medicine, and still I am not doing it. I am also not even filling up the Form 27. So therefore the government has no other alternative, but it would wait for 3 years, and after 3 years, if I am not producing such a medicine at the local level, then what the government does, it provides the license to the third party to produce that medicine. Okay, now this may seem that the Indian government is violating the TRIPS of WTO, but it is not violating the TRIPS of WTO. TRIPS has given there is a provision in TRIPS which provides the governments to do such an act. Okay, that provision was given in the Doha Declaration. So therefore India's actions under Form 27 will not violate the TRIPS or Doha Declaration. So this thing you have to remember. And India also became a member of the international patent regime in 2005. Now why would India join the patent regime, international patent regime? Because there are many headaches with these patents, but it joined it because it wanted to take the benefits of this technology transfer. Now a company in Switzerland, a pharmaceutical company in Switzerland, it comes to India and it takes a patent for a particular product. Okay, and it does not produce that product in India, and it will and because it has a patent in India, it will not allow any other company to produce such a product. So therefore such kind of a monopoly is not acceptable to the Indian government. So therefore Indian government has come up with various provisions in this Patent Act which allows this government to give license to the third party if these fellows do not fill up this Form 27. Another important thing to remember is this Section 83 of the Patents Act. Now this is important. Now the Section 83 of the Patent Act states that the patents are granted to encourage invention. This is very important, and to secure that the inventions are worked in India on a commercial scale and to the fullest extent that is reasonably practical. Okay, so therefore these patents are issued to encourage inventions within India, to commercialize these inventions within India. Okay, and the monopoly granted to the patent is not merely to import the invention. So that's what the section 83 of the Patents Act is talking about, the commercialization of that particular invention, and it is also talking about the technology transfer. So therefore, if a company from Switzerland comes to India, then the government feels that that company has to transfer the technology to another company so that these products can be produced on a commercial scale. So therefore, once the medicines are produced on a commercial scale, that will have a very positive impact on the health scenario of our country. So therefore, the title of this particular of this particular article, Patents and Protecting Public Health, is valid. This is about this article of Patents and Protecting Public Health. Thank you.